Hello, I'm Christy Carbone-Gall, the Bernalillo County Probate Judge. We have prepared this video to address the frequently asked questions for your review before you complete your probate paperwork. The probate paperwork can be found at bernco.gov/probate-court, and there is paperwork for probate cases where there is a will and paperwork for probate cases where there is no will. Both sets of paperwork come with detailed instructions which should be read through, in addition to reviewing this video before you complete the paperwork. Once you have done that, if you still have questions, you can contact our court and my staff by emailing probate@bernco.gov or by calling us at 505-468-1229 with your questions. As you would expect, we are behind in the opening of probates due to COVID. We are taking limited in-person appointments. You can continue to mail in the probate documents with the filing fee and they will be processed in the order received. We understand how important the probates are to the basic tasks that are necessary, like obtaining access to bank accounts to pay bills. We are doing our best to process the probates as quickly as we can, and we appreciate your patience.
When does a probate have to be opened?
A probate is not always required when a person dies. A probate needs to be open if there are any accounts, deeds, etc., solely in the decedent's name, and there is not a beneficiary designation naming who will receive the asset. Another thing to consider is that if a decedent has less than $50,000 in assets, not including real estate, there is an alternative to a probate called an affidavit of small estate. And you need to consider whether there are more debts than assets in the estate. If you file a probate, you have to go through the process of dealing with the creditors of the person who died. You are not personally obligated to pay the person's debts unless you are a co-signer on the debt or unless it is community debt, meaning that you are the spouse of the person who died and this debt was incurred during the marriage.
Who is allowed to open a probate?
Who can open a probate depends on whether the decedent has a will. If there is a will, then the person named in the will as the executor or personal representative has first priority to be appointed as the personal representative. However, sometimes the person named in the will is not willing or able to serve as the personal representative. In that case, it can be the next person named in the will to serve, or it can be another person interested in the person's estate. If the person that opens the probate is not the one named in the will, or if there is not a will, then the legal spouse has first priority to open the probate and be appointed as personal representative of the estate. If the decedent was not married, then the adult children of the decedent have the priority to serve. If there is more than one person with the same priority, the applicant must get the consent of the others with the same priority. Those consents need to be attached to the application for probate.
Do I file my probate in probate court or in district court?
The probate court has jurisdiction to open a probate when there is no conflict among the interested parties. If there will be a fight over the appointment of the personal representative, a fight about debts, or a fight about the validity of the will, these probates need to be opened in district court as we do not have jurisdiction to deal with these issues.
How do I know a will is valid?
When you file a probate with a will, you have to provide us with the original will. The probate court keeps the original will in its permanent records. In order to be validly executed, a will needs to be signed and dated by the person and needs to be witnessed by two others. Traditionally, the will is notarized, but it does not need to be. A notary can be one of the witnesses. If you do not have the original will, you cannot file the will to be probated in the probate court.
What do I need to do to open a probate case?
If it is necessary to open a probate, then you can purchase a packet from the probate court for $5, or you can download the form from bernco.gov. Please read through the instructions and fill out the first 4 documents in the packet, starting with the application. Bring the completed documents to the probate court, either by hand delivering them to the customer service desk in the county building or by mailing them to the probate court, along with an original death certificate or other proof of death and a $30 filing fee. Please make sure that you've included the filing fee or we cannot docket your probate. Please note that our ability to meet in person is not possible due to COVID in order to keep our staff and the public safe. We are available, though, for phone appointments and available by email.
What can I do if the personal representative isn't doing what they're supposed to be doing?
Please consult an attorney if there are any problems. We cannot give legal advice.
Is there a time limit to open a probate?
You have 3 years to open a probate. If it has been longer than 3 years, you have to open it in district court if there is a will that needs to be enforced. If there is not a will, or if the interested parties consent to proceed without the will, the probate court can do the probate.
Are the forms hard to fill out? And can you help me fill them out?
The forms in the packets are written for people who are representing themselves. The instructions are very informative. They are not difficult to fill out. Some issues that regularly occur are the following. The application asks for your relationship to the decedent. However, the application does not provide a line to fill in your relationship. Please place your relationship to the decedent, for example, you are their son, daughter, niece, nephew, right after the first line on the application. The form asks for a list of spouse, children, or other family members. Please document if there is a spouse or not. You need to list everyone in the will, including charitable organizations. Please list all children, even if a child has died. If a child has died, then you need to note that whether that deceased child has children. In this same list, we ask you to name their relationship to the decedent. For example, spouse, adult son, adult daughter, grandchild, with their age if they are a minor child. If there is a will, we also ask you to state whether the person listed is a devisee, which means the person named as a beneficiary in the will. We also need you to identify them as an heir so that if the will is not valid, we know who would inherit pursuant to the statute. If there is no will, then the list needs to identify their relationship to the decedent and identify them as an heir. If the person applying to be the personal representative does not have priority, have you provided the court with your consents for your appointment from all of the others with equal priority? We typically have to follow up to obtain the consents. If you are unable to obtain the consents, then you should not be filing in the probate court. You will need to file in district court. We regularly have probate packages dropped off without the filing fee. Please make sure to attach the $30 filing fee. We take checks and credit cards. We need a death certificate or other proof of death. Even though a death certificate has some of the information required in the probate application, you need to include that information on the application as the death certificate is not part of the application. The application must contain all the information requested as we cannot complete the forms for you. We can't help anyone fill out forms, but suggest if there are any problems that you consult an attorney. If you file in district court, then you will have to request a hearing from the district court or your case will not move forward. You may find it necessary to hire a lawyer to help at that point. Thank you for taking the time to watch this video. By submitting a complete package, including your $30 filing fee, your probate will be completed more quickly. Please do not hesitate to call the court or email us if you have questions. Remember, we cannot provide legal advice, but can answer questions about the forms. We understand that this is typically a very difficult period of time for people dealing with the death of a friend or a family member, and we hope to make this process as smooth as possible.